Welcome back, everybody. In this session, we will be discussing the part 1 of the Indian Evidence Act. The dates in total we have 3 parts, part 1, 2 and 3. Then we have total sections 167. We have 2 dates, 15th March 1872 and 1st September 1872. That is the enforcement date and that is the assent date. Preamble says consolidate, define and amend, and that is Act 1 of 1872. Now let's just go very quickly from the part 1 because it is very easy and yes, it is asked in the exam. It extends to whole of India and applies to all judicial proceedings in or before any court, including court-martials. So Evidence Act is also applied to court-martials other than which is not applicable here: Army Act, Navy Act and Air Force Act. Apart from these 3, other court martial is there, then it would be applicable, but it won't not be applicable. So they are not applicable to affidavits or proceedings before an arbitrator. Okay, not applicable before affidavits or the proceedings before the arbitrator. Commencement we have just read, 1st September 1872. Second, repealed. If you want to read the second schedule and 1938 repealing act, if you can remember, then you can add the 1938 act repeal the section 2. Section 3 is important. It is the interpretation clause. In this act, following words and expressions are used in the following senses unless a contrary intention appears from the context. What do you mean by court? A court include all judges and magistrate and all persons except arbitrator. The court does not include arbitrators and every other person who is legally authorized to take evidence. Judges, magistrate and any other person who is legally authorized to take evidence. What do you mean by fact? The fact means and includes. Fact means and includes anything state of mind. So you need to mean that it is an inclusive definition. It includes state of things, relation of things. So state, relation, capable of perceived by the senses. Capable of being perceived by the senses. Any mental condition, this was the physical, and we have psychological, and that is mental condition of which the person is conscious. There are certain objects arranged in certain order. That is a fact. The man heard or saw something. That is the fact that the man said certain word. Is the fact that a man holds a certain opinion and had a certain intention, acts in good faith or fraudulently, uses a particular word in particular sense, or was at specified time conscious of particular sensation is fact. That man has a certain reputation is also a fact. Then moving forward, we have relevant. The relevancy, we have just like chapter 2 is all about relevancy. But what do you mean by relevancy? The one fact is said to be relevant to another when one is connected with other. So we have to see the connection. One fact is said to be relevant to another when it is connected with other in any of the ways referred to in the provisions of in relation to the relevancy of fact. तो चैप्टर 2 में आपको कुछ कनेक्शन दिखाना चाहिए होता है अदर फैक्ट से, तो वो आपका रेलेवेंट हो जाएगा. फैक्ट एंड इशू क्या होता है? फैक्ट एंड इशू मीन्स एंड इंक्लूड्स एनी फैक्ट फ्रॉम विच आइदर बाय इटसेल्फ या खुद या किसी कनेक्शन से क्या पता लगता है? एग्जिस्टेंस, नॉन एग्जिस्टेंस, नेचर और एक्सटेंट ऑफ एनी राइट, लाइबिलिटी, डिसेबिलिटी असर्टेड और डिनाइड इन एनी सूट ऑफ प्रोसीडिंग नेसेसरली फॉलोज. तो ये आपको ऐसे ही रटा होना चाहिए कि fact and issue means and includes any fact either by itself or in connection with any other. shows क्या करता है? existence, non-existence, nature or extent of any right, liability, disability asserted or denied in the proceeding that necessary follows. Whenever under the provisions of the law for the time enforced relating to civil procedure any record issue of fact that issue to be asserted or denied, an answer is also a fact and issue. A accused of murder of B, A at this trial facts may be an issue that A caused B's death, that A intended to cause B that B's death, A had received grave and sudden provocation from B at the time of the act, B caused B which caused B by reason of unsoundness capable of being nature. All these are facts and issue. Then we have document. Documents mean an express described upon any substance by means of letters, figures or marks, or by any of those means intended to be used or which may be used for the purpose of recording that matter. A's writing is a document. Words printed, lithographed, photographed are documents. These are like very silly questions that are being asked in the exams straight away from the BERAT. Is writing is a document. Words printed, lithographed, photographed are documents. A map or a plan is also a document. An inscription on metal plate is a document. A caricature is also a document, or a stone inscription is also a document. Evidence. What do you mean by evidence? Very important. Evidence means it includes all statements. Whatever statements which the court permits are required to be made before it by the witnesses, any relation to the matter under inquiry. Such statements are called oral evidence. So now evidence has been distinguished between oral, documentary, and you can say also say electronic. So oral evidence is what? All statements which the court permits or requires to be made by the witnesses in relation to the matter of fact. Documentary evidence is all documents including electronic records produced for the inspection of court. The documentary evidence, all documents produced for the inspection of court. What do you mean by proved, disproved and not proved? Again, very important distinction comes for 2 marker. Proved is a fact. It is to be proved when after considering the matters before it. So the court first will consider the matter before it, and the court either believes it to exist, or consider its existence so probable that a prudent man ought, under the circumstances of the particular case, act upon the supposition that it exists. So court says, they see, I have a particular matter at my hand, I am considering it, and I believe it to exist. Now either you can believe on my testimony, or I believe that a prudent man would believe it to be exist and will act upon it as it exists. Alright, disproved. A fact is said to be disproved when after considering the court either believes it does not exist, in prove it exists, disproved we believe that it does not exist, or considered its non-existence so probable, non-existence so probable, and ought in the circumstances to a particular to act upon the supposition that it does not exist, and not proved when it is neither proved or nor disproved. Alright, India means a territory that is including Jammu and Kashmir. Okay, remember this, the expression certifying electronic signature, electronic form, secure shall have the meanings respectively assigned to in the IT Act 2000, that is 21 of 1000. Now section 4 is again very important, that talks about presumptions. Presumptions 4 is may presume. Whenever it is provided by the act that court may presume a fact, it may either regard fact as proved unless and until it is disproved, or may call proof for it. So when there is may presume, we will have lot of sections in which we will be presuming something. So when we have may presume, then court will consider it as to be proved. Consider that as it's proved unless and until it is disproved. Unless and until it is disproved, plus may call for proof, and तभी तो disprove होगा जब proof मंगाएगी. ठीक है. Shall presume whenever it is directed by the act that court shall presume a fact, it shall regard as proved unless and until it is disproved. Here no proof necessary, मतलब no proof would be called. Okay, कॉल नहीं किया जाएगा आपका, यहाँ पे आपको मंगाया जाएगा, यहाँ पे आपको नहीं मंगाया जाएगा. आपको ये प्रूव मानेंगे until and until disproved. Conclusive proof. When one fact is declared by the act to be conclusive proof of another, the court shall on proof of the one fact regard the other as proved and shall not allow evidence to be given for the purpose of disproving it. यहाँ पे मंगाया नहीं जा सकता पर आप दे सकते हो. यहाँ पे no further proof. Conclusively आपने उसको मान लिया है. यहाँ पे 3 सेक्शन है. 1 सेक्शन इज आई थिंक सो 112 तो है आपका, एक शायद 40 की रेंज में है कि ये है, and we'll see. Okay, so we'll mark where we have conclusive proof and where we have shall and may presumption. This was the chapter 1. Moving to the chapter 2, this chapter would be stretching from section 5 to not 55. Yes, we can say it is for 55 section. Yes, chapter 5, chapter relevancy. Yes. Okay, let's start. Chapter 2, relevancy. Chapter 5, section 5, evidence will be given of facts in issue and relevant fact. Only the evidence which are required for the fact in issue and the relevant fact would be admitted in the court. Evidence may be given in any suit or proceeding for the existence, a proceeding of the existence of non-existence of every fact और आएगा यहाँ पे, ठीक है. Or of every fact in issue such as the fact as it herein declared to be relevant and of no others. Only this. The section shall not enable any person to give evidence of fact which is disentitled to prove of any provisions for the time being included under the Civil Procedure Code. Okay. We will see disentitled to prove कब होता है वो. हम इसी में भी एविडेंस एक्ट में भी कुछ ना कुछ दे रखा है आपका. A is tried for murder of B by beating him with a club with the intention of causing his death. At A's trial, the following facts are in issue. A is beating with a club, A causing B's death by such beating, A intention to cause B's death. All these are relevant and evidence can be given of all such facts. A suitor does not bring with him and have in readiness a production at the first hearing of the case a bond on which he relies. This section does not enable him to produce the bond or prove its content at subsequent stage of the proceeding, otherwise than in accordance with the conditions prescribed under the CPC. This is the illustration to your explanation. Now moving to section 6, again very important. Here you just need to remember the same transaction. Relevancy of facts. Which facts are relevant if they are forming the same transactions? Facts which, though not an issue, they are not an issue, are so connected with fact in issue as to form part of the same transaction, are relevant whether they occur at the same time or place or at different times or places. Alright, illustration to this. A is accused of murder of B by beating him. Whatever A was said or done by A or B or by the bystanders. Here, remember, this is asked in your MCQs. So, A is accused of murder of B. A is accused of murder of B. Whatever is said by A, B or bystanders, even by whatever was said by bystanders would be considered as part of the same transaction. At the beating would shortly before or after it's the form of the same transaction is a relevant fact. So, A, B and even by the any statement made by the bystander would be considered. Next illustration. A is accused of waging war against the government of India by taking part in an armed insurrection in which property is destroyed. Now property is being destroyed, troops are attacked and gates are broken open. The occurrence of these facts is relevant as forming part of the general transaction, though A may not have been present at all of them. But there was the same event, but there were some consequences. So this is not necessary that A must be present at all of them, but they would be considered in the same transaction. A sues B for libel contained in a letter forming part 4 of a correspondence. Letters between parties relating to the subject matter out of which libel arose, forming part of the correspondence in which it is contained, are relevant facts, though they do not contain the libel itself. Part of correspondence will be considered as same transaction. The question is whether certain goods ordered from B were delivered to A. The goods were delivered to several intermediate persons successfully. Each delivery is a relevant fact. This is also asked in your MCQs. Next facts which are occasion, cause or effect of fact and issue. So in 7 they ask what is not is present under section 7. So under section 7 we have occasion, we have cause and we have effect of fact and issue. Alright, so occasion kab hua, we'll mark here in the illustration itself. Alright, occasion, आपको कौन सा occasion मिला, उसके क्या cause हुआ, उससे क्या effect हुआ, आपके fact and issue. Facts which are the occasion, cause, effect. Immediate भी हो सकता है, otherwise of relevant fact in which constitute the state of things under which they happened, which afforded an opportunity. Okay, यहाँ पे आपको क्या मिली, opportunity मिली for the occurrence of transactions are relevant. जैसे कि एक क्वेश्चन इज वेदर ए रॉब्ड बी. अब ए ने रॉबरी कर लिया बी की, अब कैसे करा. द फैक्ट दैट शॉर्टली बिफोर रॉबरी ए बी वेंट टू फेयर विद मनी in his possession and that he showed it on the mentioned fact that he had to the third person are relevant. This is opportunity plus occasion. Okay, the question whether A murdered B, marks on the ground, that is effect या cause भी लगा सकते हो. Produced by the struggle at or near place where the murder was committed are relevant fact. The question whether A poisoned B, the state of B's health, opportunity before the symptoms ascribed to poison, habits of B known to be afforded an opportunity for the administration of poison are relevant. Now 8 is again important, that is motive, previous or subsequent conduct. Preparation and motive comes under section 8, previous or subsequent conduct. Any fact is relevant which shows or constitutes a motive for preparation. Any fact is relevant fact. The conduct of any party or of any agent to party, any suit or proceeding in reference to any fact and the conduct an offense against whom the subject matter is relevant if such conduct influences. Now what happened if that conduct should influence or is influenced by any factor in issue relevant ban and whether it was previous or subsequent thereto. The word conduct in this section does not include here. The conduct does not include statements unless those statements accompany and explain acts other than the statements. But this explanation is not the fact the relevancy of statements under any of this section. That would be applicable under 6. So it is saying that here conduct में आपकी statement नहीं आएंगी अगर वो आपके एक्सप्लेन नहीं कर रही हैं और चीज़ों को, बट वो बिना चीज़ों के एक्सप्लेन हो रहे तो आप उसको रेजिस्टे में लगा सकते हो. एक्सप्लेनेशन 2, व्हेन कंडक्ट ऑफ एनी पर्सन इज रेलेवेंट एनी स्टेटमेंट मेड टू हिम और इन हिज प्रेजेंस अफेक्ट सच कंडक्ट इज रेलेवेंट. ऑब्वियसली बात है, आपको बस एक्सप्लेनेशन 1 को इन्होंने एलैबोरेट कर दिया. A is tried for murder of B. The fact that A murdered C, that B knew that A had murdered C, that B had tried to extort money from B by threatening to make his knowledge public are relevant. This is the motive, you can say, not preparation but motive. तो क्यों मारा उसने? क्योंकि उसको पता लग गया था कि उसने उसको मारा है और वो उसको कह रहा था कि मैं तो बता दूंगा सबको, इसीलिए दैट इज मोटिव. A sues B upon a bond for payment of money. B denies making the bond. Now A ने sue करा B को आपके बॉन्ड के ऊपर कि मेरे को ये दो. बी ने मना कर दिया, मेरा तो ये कोई बॉन्ड ही नहीं है. फैक्ट दैट एट द टाइम एंड बॉन्ड वॉज एलिज्ड टू बी मेड बी रिक्वायर्ड मनी फॉर अ पर्टिकुलर पर्पस इज रेलिवेंट. तो ये भी मोटिव बता रहा है. जब बॉन्ड बन रहा था तब बी को पैसे चाहिए थे, ये पता लग रहा है, तो ये हो सकता है मोटिव. ए इज ट्राइड फॉर मर्डर ऑफ बी बाय पॉइजन. द फैक्ट दैट बिफोर द डेथ ऑफ ए प्रोक्योर्ड पॉइजन सिमिलर टू दैट विच वॉज एडमिनिस्टर्ड टू बी आर रेलिवेंट. ये आपका आता है प्रेपरेशन में. Next, the question is whether a certain document is the will of A. The facts that not long before the date of the alleged will, A made an inquiry into the matters to which the provisions of the alleged will relate, that he consulted वकील्स in reference to making that he caused drafts. ये भी आपके क्या है? Preparation है. Next, A is accused of crime that either before or of the time or of the alleged time A provided evidence would tend to give the fact of the case an appearance favorable to himself, or that he destroyed or concealed evidence or prevented the evidence who had might have evidence of one. ये भी आपका मोटिव में आता है. ओके, प्रेपरेशन में भी आ सकता है आपका. A is the question is whether A robbed B. Fact that B was robbed. C said in A's presence that police are coming to look for the robber. Then immediately A ran away are relevant. This is motive also. मोटिव नहीं कहेंगे, इसको हम कंडक्ट कहेंगे. देखो इसमें कंडक्ट भी आता है, प्रीवियस और सब्सिक्वेंट कंडक्ट, राइट. तो ये आपका कंडक्ट हो गया है. इवन दिस इज ऑल्सो दिस इज either for the time A provided evidence which would tend to give the facts of the case an appearance favorable to himself, or that he destroyed or concealed evidence. ये आपका कंडक्ट में आएगा, ये भी आपका कंडक्ट में आएगा. ए क्वेश्चन इज वेदर ए ओज बी था 10,000 रुपये. ए ने पूछा था सी से कि मेरे को पैसे दे दे, और डी ने कहा ए की प्रेजेंस में कि मैं नहीं एडवाइस करता कि तो इसको पैसे दे फॉर बी, क्योंकि इसको बी को पैसे देने 10,000. ए वेंट अवे विदाउट मेकिंग एनी आंसर. ये भी आपका क्या होएगा? रेलिवेंट होगा. MCQ यही आता है कि रेलिवेंट है कि नहीं. सो दैट इज़ रेलिवेंट अंडर सेक्शन 8. क्वेश्चन है ए ने क्या क्राइम करा है. ए भाग जाता है आफ्टर रिसीविंग अ लेटर वार्निंग हिम की इंक्वायरी शुरू हो गई है क्रिमिनल की, और कंटेंट्स ऑफ द लेटर आर रेलिवेंट. तो लेटर के कंटेंट प्लस उसका कंडक्ट आपका दोनों का रेलिवेंट है. ठीक है. नेक्स्ट, ओनली फ्यू इलस्ट्रेशंस आर लेफ्ट. के तक ही है. A is accused of crime, that fact that after commission of knowledge he absconded or in possession of property or attempted to conceal things. छुपा रहा है, भाग गया. ये आपके कंडक्ट में आ गया. A was ravished. ये आपकी ये वाली illustration आती है. The fact that shortly after the alleged rape she made a complaint relating to the crime, the circumstances under which that is relevant, और दूसरे में आपका not relevant आएगा. The facts that without making a complaint, उसने complaint तो लिखी नहीं, ऐसे बोल रही है, she is not relevant. The fact that without making she said that she had been not relevant as conduct in the though it may be relevant as direct declaration under section 332 as corroborative evidence, वैसे नहीं माना जाएगा ये. तो क्वेश्चन इज वेदर ए वाज रॉब्ड. सेम है, उसने दे दिया, कंप्लेन दे दी, कंप्लेन तो दी नहीं, तो वो आपका नॉट रेलिवेंट हो जाएगा. अब आते हैं हम 9 पे. 9 स्टार्ट ही आपका होता है फैक्ट्स नेसेसरी टू एक्सप्लेन और इंट्रोड्यूस रेलिवेंस फैक्ट. आपकी ये क्या बताने लग रहा है. आप बता रहे हैं कि हम या तो आपको कुछ एक्सप्लेन कर रहे हैं या हम कुछ इंट्रोड्यूस कर रहे हैं. तो ये जो TIP है आपकी टेस्ट आइडेंटिफिकेशन परेड, ये आपको एक्सप्लेन भी कर रही होती है, ठीक है। फैक्ट्स नेसेसरी टू एक्सप्लेन एंड इंट्रोड्यूस अ फैक्ट एंड इशू रेलेवेंट फैक्ट और विच सपोर्ट, यहाँ सपोर्ट ही करते हैं हम TIP से, सपोर्ट और रीबट एंड इन्फ्रेंस सजेस्टेड बाय फैक्ट और रेलेवेंट और विच एस्टैब्लिश द आइडेंटिटी, ये आइडेंटिटी ऑफ एनीथिंग और अ पर्सन के आइडेंटिफिकेशन के लिए जाते हैं, आइडेंटिटी ऑफ थिंग और पर्सन हुज आइडेंटिटी इज रेलेवेंट और फिक्स टाइम और प्लेस at which it happened or show the relation of parties to whom such fact was transacted are relevant and also for as necessary for that purpose. The question is whether a given document is the will of A. The state of A's property and of his family at the date of alleged will may be relevant fact. यही आता है irrelevant है नहीं irrelevant है. A sues B for libel imputing a disgraceful conduct to B affirm that matter alleged to be libelous is true. The position and relations of the parties at the time when the libel was published may be relevant facts. As introductory, the particulars of dispute between A and B about matter unconnected with the alleged libel are irrelevant. Unconnected है तो relevant होंगे. Though the fact that they were disputed may be relevant if it affected the relations between the party between A and B. अगर वो relevant हो सकते हैं अगर उन्होंने relations ख़राब कर दिया तो. आपकी illustrations F तक की हैं. C कहता है crime करा है का फिर क्या होता है कमीशन ऑफ क्राइम के बाद ए भाग जाता है, दैट इज रेलेवेंट अंडर 8 एज सब्सिक्वेंट डेट व्हेन अफेक्टेड बाय फैक्ट एंड इशू, द फैक्ट दैट एट द टाइम व्हेन ही लेफ्ट होम ही हैड सडन एंड अर्जेंट बिजनेस, तो ये जो आपका है ये भी रेलेवेंट होगा क्योंकि वो एक्सप्लेन कर रहा है, तो वो आपका 8 में नहीं जाएगा, मतलब 9 में आपका वो चला जाएगा. द डिटेल्स ऑफ बिजनेस ऑन विच ही लेफ्ट आर नॉट रेलेवेंट, जो आपके ये जो बिजनेस के काम से गया है अर्जेंट और सडन, तो ये रेलेवेंट नहीं है एक्सेप्ट अगर वो शो करते हैं कि बिजनेस वो सडन एंड अर्जेंट था. A sues B for inducing C to break a contract of service made to him with A. C on leaving A's service says to A, I am leaving you because B has made me a better offer. This statement is relevant as explanatory to the C's conduct which is relevant as fact and issue. A theft करता है, is seen to give stolen property, उसने B को दे दी, who is seen to give it to A's wife. ठीक है, तो A ने theft करी, A ने B को दे दी और B ने A की wife को दे दी. फिर B कहता है कि A says to you hide this. B statement is relevant as explanatory of the fact which is part of the transaction. B says as he delivers it. तो जो B की statement है ये relevant हो जाएगी. And A is tried for riot and is proved to have marched at the head of the mob. A को try कर रहे हैं हम, ये बहुत बार आता है MCQ में. इसकी illustration है F कि A try कर रहा है, A का ट्रायल हो रहा है फॉर राइट और वो इसके लिए हो रहा है क्योंकि वो मार्च कर रहा था एकदम आगे और सारे लोग क्या चिल्ला रहे थे, जो भी चिल्ला रहे हों वो सारी रेलिवेंट चीज़ें होंगी एज एक्सप्लेनेटरी टू द नेचर ऑफ ट्रांजैक्शन. ठीक है, दिस इज सेक्शन 9 एंड वी विल कंटिन्यू टू फ्रॉम सेक्शन 10 इन द नेक्स्ट सेशन. आई होप that the reading of each and every word of the Bail Act is somewhere beneficial to your revision. Thank you. See you in the next session.